Hi, I'm Steve Carlson. I've been the Minnesota Independence Party candidate for the U.S. House in 2012 in what is now a safe Democrat district, but which used to belong to former presidential candidate Eugene McCarthy. And in 2014, I was elected statewide as the party's nominee for United States Senate against the infamous Al Franken. Now this year, I'm running for president and seeking the restoration of the independent party's major political party status. And if I don't win in the Supreme Court or the U.S. Senate, I'm asking independent voters in Minnesota and across the nation to sign a petition to get me on the ballot, or other independents on the ballot. In Minnesota, based on a strong show by Ross Perot in 1992, the Independence Party of Minnesota was founded, sometimes known as the Reform Party. And actually, Donald Trump won the California presidential primary in 2002 with the Reform Party. Jesse Ventura won the Minnesota governor's race in 1998. And I won the statewide party primary in Minnesota to run against the infamous Al Franken for the U.S. Senate in 2014. But that major political party status and the right to put candidates on the general election ballot through party primaries, usually at the top of the ballot, was withdrawn as a result of a series of unconstitutional actions beginning in 2012, which Minnesota courts refused to correct, until under assault by the Minnesota Democrats and Minnesota Republicans, our candidates, for the first time since the party was founded by the Ross Perot movement in 1992, all fell below 5%. That was the result of an invalid, unconstitutional election. Problem, which is before the U.S. Supreme Court, and it's case number 15-6205, Carlson versus Mark Dayton, Governor et al., really started when I began to speak out against unconstitutional gender, race, homosexual, and ethnic quotas imposed by the state of Minnesota in support of the DFL party. As a result of that, my access to voter email addresses in my congressional district was taken away at the final days and weeks of the general election. This resulted in election contests under Minnesota law in 2012 and 2014, where you challenge and contest the conduct of that election and the results of that election. Now, this trampling of the civil rights of independent voters, as clearly stated by the Supreme Court in 1983 in the case of the independent presidential campaign of John B. Anderson, is a clear violation of the freedom to associate as independent voters to put a candidate on the general election ballot against the two big national parties. That's in the First Amendment. And Minnesota and the Democrats, who have controlled all of the state's positions as governor, like Chief Elections Officer, called Secretary of State, that's Mark Ritchie, and Minnesota Attorney General, Lori Swanson, the DFLer, have been violating many U.S. constitutional provisions, as well as Minnesota election law, in order to destroy intentionally the Minnesota Independence Party, which is really the strongest vehicle in the nation structurally for independent voters to associate and put candidates on the general election ballot against the Democrats and Republicans. Those two party establishments hate it. And Donald Trump is experiencing this right now. This lawsuit, this petition for certiorari to the United States Supreme Court, has grown out of the state of Minnesota, including Minnesota state courts, blocking of election contests, which, as I point out here, are required by the United States Constitution in Minnesota. Contest procedures vary slightly from state to state. The suit requests a number of things, focusing on the need for the governor to follow state law and allow the contest to proceed. Since he illegally issued Al Franken an election certificate in violation of the rules of the U.S. Senate, this was a Senate race, and the senators are actually the sole judges of the contest. And Minnesota judges and officials conspired to usurp the Senate's power and block the procedures required under Article 1, Section 4 of the U.S. Constitution. I ask that the IP major party status be restored, and that the contest proceed by continuing to collect evidence in Minnesota State Court to send to the U.S. Senate, so that the Senate can carry out their duty under the Constitution, including their duty to guarantee Minnesota a Republican form of government with free and fair elections. Here's the actual statement of the case as